On Justice Breyer's question, I think you're saying if the interests were truly anti-corruption, they shouldn't allow any post-election contributions because each person is similarly situated in terms of threatening that corruption interest, whether it's the first one or the 87th one. Is that?
That's precisely
well,
my
each
point.
person might be similarly situated, the first and the 87th, but the candidate is not similarly situated. The candidate with $3,000 of debt is a lot less likely to start thinking about how he can sell his votes than the candidate with $500,000 of debt. So the candidate is in a very different situation the more the debt mounts. And Congress here came in and said, these are hard things, we're striking balances. We're picking $250,000 at the time where candidates really start worrying about the kind of debt that they have and the kinds of things that they can do to reduce that debt. So even though it is formally true that the 87th person is the same as the first person in terms of they both spent $2,900, at the 87th person, the candidate is in a very different situation and is thinking about those quid pro quos.
He's thinking about them, Your Honor, because Congress has not allowed the 87th person to come in and make that claim. And I'm glad you have focused on the candidate, and the candidate, as the candidate is deciding whether he's going to call upon his own financial wherewithal to fund speech, Your Honor, First Amendment political speech. He is going to think twice. Yes, if he can't afford to just give his campaign money, he's going to think twice whether or not he loans more than $250,000. In order to advocate his own money, to advocate his own election. And that was the purpose of Section 304, to make sure that the challenger didn't loan more than $250,000 to his campaign, or at least that if he did,
well, this goes back to my first
risk.
question, which I think we've probably covered in sufficient detail, but it's just the same as Congress saying we're not going to allow a candidate to go get a $500,000 contribution from somebody. That's another way that the candidate could finance his campaign. So
I'm sorry.
This is not candidate expenditure. This is candidate financing of a campaign. It's a structure to allow a candidate to finance a campaign without spending any of his own money.
Your Honor, if I understood your point correctly, I don't think it's at all comparable that you have many contributors contributing only the base limit at most versus a single contributor contributing $500,000. The base limits, again, under McCutcheon and under common sense, are Congress's judgment that anything at that amount or below has no cognizable risk of corruption.
Right. I was just suggesting that the kind of burden this is the kind of burden that contribution limits are, not the kind of burden that expenditure limits are. And our law treats those two burdens very differently. That's the point I was making.
And I well understand that. And my response is that these are expenditures, Your Honor, and the law that governs contributor limits applies to all of them across the board.
But don't
it doesn't
you have
say that the first 86
I don't
are preferred
understand,
to the
Mr.
87th.
Cooper, why you contest that this is like a gift. I guess this puzzles me. If I have a debt of $10,000 and somebody comes along and says, "You're doing such a good job, I'm going to pay that debt off for you," isn't that a financial benefit to me?
Of course.
It's a gift.
And that would be, you're describing a gift, but the repayment of a loan, Your Honor, is not a gift.
But a third party is repaying my loan, and so the third party is providing a gift to me.
Your Honor,
I mean, that's just like, of course, right?
Your Honor,
If a third party says, "You're doing such a good job, I want to repay your loan for you." I mean, one day I had a $10,000 loan. The next day I don't. I'm $10,000 richer. Somebody just made me a $10,000 gift.
Your Honor, if a contributor comes in and gives the candidate a $10,000 gift, then yes, that violates not just the gift statutes, but if there's a quid pro quo involved, the bribery statutes. This is we're
that's the
talking about
entire point
campaign
of this law. I mean, the entire point of this law is that we start getting worried when people start repaying the candidate's indebtedness, because that's just another way of putting money in his pocket.
Your Honor, what about the rest of the campaign's debts? This campaign ended up with $2.7 million worth of debt. Only 10%, less than 10% of it was the candidate's debt. Is every contribution made after the election a gift to all of those creditors? Of course it's not, and nobody would view it that way. It's not a gift, Your Honor, when when the debtor pays the creditor what the creditor is owed. And that's what we have here. Yes, it is true that all of the campaign's debts are paid by contributions limited by the base contribution limits. All of them are, but the candidates' debts don't stand in any different shoes from the ad agencies or the consultants or the landlords of a campaign.
Well, it stands in